Hi friends, welcome to Law Chat 101 with your legal BFF, Girija Patel. In today's episode, I'm actually going to be talking about some of the things that you as an employee or independent contractor should be looking out for in a contract before you sign it. Lately, I have come across so many hot topics in the news, plus also potential clients and other people in the industry talking about how do we get out of this non-compete, or how do we make sure that we can still work but still be able to sign a contract that we're getting even though there's a non-compete there. Or, oh, I didn't know I signed this non-compete. What am I gonna do? Or even, oh my gosh, I thought this intellectual property was mine. I thought this Instagram account was mine. This social media platform was mine. So these are some of the really big topics that keep coming up and the issues that keep coming up. And I thought that, you know what? Let me address some of the key things that you need to be looking out for if you are signing a contract with an employer. It doesn't matter in the capacity of the employee or a capacity of an independent contractor, part-time, full-time. It's just things that you need to look out for. So here we go. Number one, what is the scope of your job? Now, a lot of times if you're working into a company as an employee, the scope will somewhat, if you have an employee contract, sometimes you don't even have it, but if you have an employee contract, the scope will kind of tell you what you're supposed to be doing, your job title, your job description, and then also it will probably have a catch-all phrase that says, and anything else that they ask you to do. Because quite frankly, practicality, that's what happens in companies. And sometimes you do have to take over certain things that may not be necessarily part of your job description, but something that your employer wants. But if you're an independent contractor, you really need to have the scope a little bit more defined. It can't be completely having a very generic, all-rounder type of a scope unless that's the kind of job you're doing. But then we really need to assess whether the classification is correct and whether you're actually an employee. Because if you're an employee, you actually are far more immersed into the company than if you are an independent contractor. Those people who are independent contractors are generally there for a very narrow scope in their business and something that is not necessarily the pulse of the business also. So what is a scope? Understand that and make sure you're okay with it, and make sure you're also okay with if there is a catch-all phrase and if that catch-all phrase makes sense to you, and also if your job description or job title is exactly what you thought it would be, or is it something different, okay? So number two, something to look out for is the conflict of interest. So conflict of interest is not necessarily a non-compete, but what it means is that you're coming into this job capacity and the employer is saying, hey, you're coming in here, just make sure there's no conflict of interest. Make sure there's no other company that can put claims on the work that you're doing for me, and also put claims on the fact that you're doing this work for me. And so conflict of interest is very important. And you also want to come in with a clear slate and where nobody has any type of leverage over what you are doing, because it can really cause problems for your current employer, for you, and also for somebody else, third party. Number three, something to look out for is your non-compete and confidentiality, non-disparagement, and non-solicitation. So all of these are considered to be restricted covenants, and they are generally attached onto a contract that is existing. So the restricted covenants are usually your non-compete, your non-solicitation, non-disparagement, and maybe something else as well. And those are usually tacked onto a NDA or an employee contract or some other type of contract where there is significant consideration that has been given to you. So if somebody hands over a restricted covenant contract and you sign it, it may not be effective only because if they're just restricted covenants, it won't be. But if it's coming on with an NDA or an employee contract that you're about to sign, then they are considered to be enforceable as long as the state that you are in permits them. Now, there are many states that don't see non-competes or these restricted covenants necessarily as plausible or as something that has any type of effectiveness in the state. So for example, California, generally non-competes are not effective and they are not even considered to be something that's enforceable. Whereas if you come to Texas, Florida, or some other states like that, you can have non-competes that are enforceable. However, they're within parameters. They cannot be super general. They cannot be overly stretching. They have to be reasonable in nature, And they also cannot be very long in nature, because the idea is not to take away somebody's ability to do their job. The idea is just to make sure that whatever is proprietary information or information that is specific to the company that you're working for, or even their contacts and their clients and things like that, that you are not going to be taking them with you when you go to a new company and essentially stealing them from your current boss, right? So now I'm going to talk a little bit about this, because this has become a really big issue, and I'm actually going to have a separate conversation about non-competes on a separate, that's just going to be the whole topic. But in general though, when you are looking at your employee contract, please pay attention to that non-compete that's sitting over there, because that non-compete can really inhibit your ability to work in the area that you are geographically located. And it can be tough, and it can be really tough, especially if you are a high-ranking officer in that company as well. So be careful, and always know that you can, negotiate that non-compete. You can also negotiate the parameters of the non-compete also. Non-solicitation is the same thing, where you're not going to be soliciting the current clients, employees, or anybody else that's related, and to kind of just steal them and poach them and take them into your new company or into your new business that you're starting. So keep an eye out for that. Make sure you're okay with it. And honestly, ignorance is not an excuse or a defense. So if you're going to say later on, oh, well, I didn't read it, or I should have known, but I didn't read it, I didn't know what I was signing, I didn't have an attorney look at it, that's not a thing. I mean, yeah, that might be something that might be a mitigating factor in court, but it's not necessarily a defense, because ignorance is never a defense. So please read those contracts, and please pay attention to those non-competes that are sitting in there, nestled in that contract. Do not ignore it. Now, the next thing that you need to look for is the intellectual property ownership. Who owns it? So generally, if you're an employee, by default, the company owns all the intellectual property that is being created during the time that you're working and within the scope of your job as well. So if you have a handle on social media and you are talking a lot about your business on that handle, alongside the fact that you even say that this is what you do, that handle is more likely or not going to be considered to be the property of the company, not yours. So be very thoughtful about what you're doing with social media, especially. It's still a very developing area of the law. A lot of legal ease is coming out. A lot of case law is coming out also about it. However, it's still very developing, and it's ever changing right now. So if you have a handle or social media account and you want to own it completely, make sure your contract that you're signing, doesn't matter if you're an independent contractor or employee, states that if you are starting a social media account with your name on it, you own it. Because that has become a big problem with a lot of high level, they're not celebrities per se, but they're people who are making a name out for themselves, especially if they become influencers and they're working within the capacity of the company that they're working for. And sometimes the money is coming from the company, and a lot of the investment, the capital investment into their marketing of their social media also is coming from the company. So company really takes a stance that this is ours and not yours. Plus, if it's written in the contract that it's theirs, it's kind of clear night and day that it is theirs. So make sure the contract is clear on what intellectual property they do own. It doesn't matter if you're an employee or if you're an independent contractor. Now, on the flip side, with independent contractors, the default setting is that generally independent contractors own the intellectual property that's being created. So if there is something that says made for hire or assignment of rights, make sure you're okay with it. A lot of times employers do want that, because say you're making a website for somebody, I know that I would want to own my website and not have my website developer own it. So there are some things that you're making that are very specific for the employer or the person that's hired you, and they would require it to be theirs at the end of the day. So if your services or your products are something that you are going to be giving ownership to the person that you're creating it, then make sure your contract says that. But if you're giving a license for them to use it, so make sure your contract says that. And also, how are you able to use the product that you're creating or the services that you're creating for your promotional purposes also, and for your portfolio, for marketing. So have those things very clearly listed. And if they're not clear, you need to make them clear, because these are the things that become the points of contention when people are trying to exit or when they're trying to move on from something. And so there should be a clear understanding of what's happening. And also, It's really expressing the relationship that you have already discussed with the employer. The last thing, number 5, that I want to talk about is how you exit the company. Is it at will, or do you have to give notice? And if you're an independent contractor, do you have to finish the work that you're working on or some specific project before you are able to exit, or do you have to find somebody else? What is the exit strategy? And this kind of goes for the employers also, because a lot of times what might happen is that if your employee is leaving, it can be hard because they might be leaving in the middle of a launch or a middle of a project, and they might have been a key element to that project. So make sure that your contracts have something in there that talk about that. Now, a lot of times you need to leave because something happens, but make sure there is an exit strategy in there. There's steps to follow and everybody's okay with it. And even you're okay with it, and it aligns with your business and it aligns with the way you want to work for somebody, or also aligns with the type of work that you are performing for them. I hope all of these were super helpful to you, and I know they were. So please share the love, like, subscribe, and share it on your social media, and let other people know about it and benefit from all of this information that is coming your way. Again, Law Chat 101 is here for you to give you quick legal tips and business strategies for your business. And stay tuned for Law Chat with Girija every Thursday as well. And if you've not subscribed, go subscribe right now so you don't miss all the things that are coming out from this podcast and from this YouTube channel. I will see you again. Bye.